Mr. Papp, are you able to hear me okay? Mr. Papp, are you able to hear me?
Yes, sir.
Okay. Okay, we're on the record in People versus Carl Papp, file number 256857. The record should reflect Mr. Papp is present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
Morning, Your Honor. For the record, Michael Matt People.
Thank you, Your Honor. Richard Trush hearing on behalf of Mr. Papp.
Okay, so this is set for final status conference today. I know at our previous hearing, Mr. Trush, you indicated that there may be a resolution of this case. Is that still correct?
Yes, we do anticipate that a plea will happen. I would indicate I appreciate the court signing an order that allowed Mr. Papp to be transported from MDOC and housed here. That has greatly improved our ability to communicate and ultimately get to a place to resolve this.
Okay. So what is the resolution? What's the terms of the plea?
So it would contemplate a plea to count one, and the habitual offender notice would be dismissed.
Okay. Mr. Rolla, is that a correct statement of the plea offer?
It is, Your Honor.
All right. Mr. Papp, were you able to hear that?
Yes, Your Honor.
And is that the plea agreement that you've discussed with Mr. Trush?
Yes, Your Honor.
Did you want to proceed with that plea today?
Yes, Your Honor.
Can you raise your right hand, please?
And Your Honor, just one point I want to clarify for Mr. Papp, because he asked me this before. I think in the original felony complaint in the district court, the 25-year mandatory minimum, I think it was on the original complaint. The information that I have does not. It contemplates over 13, but under 16. And again, I know he raised that to me. My information doesn't reflect it, but I just want to make sure we're all speaking the same language.
So that's correct, Judge. That's why it was amended.
Okay.
Because the original information was based upon the incident occurring prior to the age of 13 at preliminary examination. That was not the testimony. So the information was amended to reflect 13 to 15.
Okay. Mr. Papp, did you have any questions about that?
No, Your Honor.
Okay. If you could raise your right hand again, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Papp, you understand that by pleading guilty to count one, which is criminal sexual conduct first degree, that the maximum possible penalty that you could face would be life in prison, along with mandatory lifetime electronic monitoring. Do you understand that?
Yes, Your Honor.
Mr. Trush, is there any circumstances here that would call for any kind of consecutive sentencing to his current sentence?
I don't believe so, because of effectively late reporting. I think the event here predates the other, so he wasn't on like bond or anything like that.
Okay. All right. So, Mr. Papp, with that maximum possible penalty in mind, then what is your plea to that charge today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're going to be giving up and waiving all of those rights, and you won't have them anymore, and that includes the right to have a jury trial. Do you understand that?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of this charge?
Yes, Your Honor.
All right. Mr. Trush, can you conduct the questioning of your client to establish the factual basis?
Yeah, so Mr. Papp, in March or around the time of March of 2023, were you here in Otsego County?
Yes.
And did you engage in sexual intercourse with a minor with the initials LL?
Yes, sir.
And at the time of that, was she under the age of 16?
By a few months.
And at the time that that occurred, were you in your 30s?
Yes, sir.
Your Honor, I think that would establish a factual basis.
Mr. Papp, by sexual intercourse, does that mean penile vaginal penetration?
Yes, Your Honor.
And were you members of the same household at that time?
Yes, Your Honor.
All right, Mr. Rolla, are you satisfied with the factual basis?
One additional question with the court's permission.
Sure.
Mr. Papp, were you also acting in a position of authority, being a member of that household with the minor LL?
What do you mean by that?
Were you acting where you sometimes took care of her where her mother wasn't available?
Her mother was always available. I don't know. To be honest, I don't understand the question. Like, what do you mean by that? Like, I paid bills, I took care of the house.
So if I could clarify, I think what he's trying to ask you, Mr. Papp, is you were not the minor's parent, but were you acting almost like a step parent?
Oh, then yes, Your Honor.
Okay.
Very good, Your Honor. Thank you. The people are now satisfied that a sufficient factual basis. Oh, we need to have venue though, Your Honor.
We did.
We did? Okay, then I missed that. Then the people are satisfied the court has sufficient factual basis to accept the defendant's guilty plea to count one as charged.
All right. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
None by the people. Thank you.
I guess one more question following up on venue. Maybe it wasn't entirely clear. Mr. Papp, I know you said that you were in Otsego County in the time frame of March of 2023, but did the sexual intercourse actually take place in Otsego County?
Yes, Your Honor.
Okay.
Very good. Thank you.
Outside of that, counsel, are you both satisfied that the court has complied with statute and foregoing the taking of this plea?
People are satisfied. Thank you.
Yes, Your Honor.
All right. Mr. Papp, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. We'll set this matter for a sentencing hearing. Mr. Trush, do you want to have Mr. Papp remain lodged here, or?
So I did discuss this with him. He would prefer to be transported back to MDOC. Given that this is going to be a PSI update, so I mean, other than the scoring information and the recommendations, I think effectively everything else is going to be identical to the PSI that was done in the other case. I don't have any objection to him being transported back. He did indicate that he would like to be present for the sentencing. So,
All right, I'm not going to do the back and forth. So,
Well, if that's the case, Your Honor, I'll do it over Zoom so I can go back to the MDOC.
okay, all right. Mr. Trush, is that something you want?
Yes, I'd rather go back to the MDOC.
So I have no objection to that. The court may recall, I mean, part of what prompted me to ask him to be transported was I became concerned that my communications with him were not being confidential.
Sure.
At this stage, I think that's less of a concern. I don't expect our strategy in terms of the PSI and how we're going to approach sentencing are particularly novel.
Okay. Yeah, I mean, I can't justify the expense because that's the preference. You know what I'm saying? So I'm happy to have an in-person sentencing. I would have Mr. Papp stay here, but Mr. Papp, you indicate pretty clearly that you would waive your right to the in-person sentencing so that you could go back to DOC.
Yes, Your Honor.
Okay. All right, so we'll schedule it as a sentencing by Zoom. So Mr. Rolla, if you can prepare the writ that way.
Making notes to that effect. Thank you, Honor.
Okay. Mr. Rolla, anything further on this file today?
Not for the people. Thank you.
Mr. Church?
Just a question in terms of the transport back. I mean, does the court need me to prepare an order or something to
Actually,
effectuate
that was
that?
covered in the original order.
Honestly, I don't know. I'm happy to sign an order. I don't know what Department of Corrections requires for them to come to pick them up. I don't know if just communication with the jail is enough, but either at your request or the request of the jail, I'm happy to sign any orders that are needed.
I will just prophylactically create a order.
Okay. Then also in light of the plea today, the court will adjourn the jury trial that's set for next week.
On that note, Judge, and I understand it's not this case, but there was also another trial scheduled during that time period. Is that trial going to be on?
We saw Mr.
Thursday, I believe. Judge?
Yeah,
We
Jason Thompson, he's on our
Is that
docket
Thompson?
today.
so we have a final status conference on that today.
Okay.
I would indicate, I don't know exactly.
Mr.
where-
Thompson is connected, so I can bring him in here in a second.
Okay. I spoke to him last night and was under the impression he was going to be here.
I thought we had already approved a Zoom appearance.
We had previously at one hearing, but I mean, at least I didn't submit anything for this hearing.
Well, we'll go forward with it regardless. Mr. Papp, we're going to go ahead and disconnect. Thank you.
Right, thank you.
All right, Mr.
Okay.
Thompson, are you able to hear me okay?
Yeah, it's just the weather. It's really bad here.
All right, we're on the record in People versus Thompson, file number 256870. If I could have counsel put your appearances on.
The record, Your Honor, my own behalf, people.
Thank you, Your Honor. Richard Trush, on behalf of Mr. Thompson.
All right, Mr. Trush, how did we want to proceed with this file today?
Well, Your Honor, I have not had contact with Mr. Thompson until yesterday. He contacted my office yesterday and updated his phone number. I was able to communicate with him in the evening. I don't know exactly what time. I would guess probably 7 o'clock or so yesterday evening. We had discussed what the offer was and discussed that there's a trial set to begin next week. I was under the assumption from my discussion, Mr. Thompson was planning to be here in person. But we had discussed that, he would contemplate what he wanted to do and let me know this morning when he got here. So that's kind of where we left things. I'm not entirely sure what his intentions are at this point. The offer is to plea to count one with a dismissal of the enhancement.
1 and 3, dismiss the others and dismiss the additional 4.
So that would contemplate the possession with intent to deliver and the DWLS dismiss the remainder.
And that's what you've discussed with Mr. Thompson?
It is, but again, it's not clear to me what his intentions were.
All right, Mr. Thompson, today
Yes.
is the plea cutoff, so today's the last day to enter into a plea agreement. Did you want to proceed with the plea or go forward with your trial next week?
No, I'd rather go forward with my trial.
Okay, so that's set for Thursday,
Yes.
Thursday and Friday.
Pull this out. I don't know if it was a 2-day. I just have a 1-day on the
One day.
10th.
On Thursday.
Yes, the 10th,
Okay,
which is Wednesday. Let me- Sorry, I'm just getting my calendar.
Your Honor, that there is an issue that is going to be created with that date.
Wednesday, December 10th is the date set for trial. Okay, what's the issue?
So, Your Honor, I slated for multiple trials on that date. There is presently one set to begin in Crawford County in front of Judge Hunter on the same date. It is a case that does have a victim. So I tend to think it probably takes priority. They're both life offenses, so I mean, functionally, they're.
Is that Crawford County or Kalkaska?
Crawford County.
Okay,
And I recognize that I should have alerted the court of that potential conflict ahead of time. On Monday, Judge Hunter made me very aware of that.
okay. Yeah. All right, let me communicate with Judge Hunter so that we can discuss. This case is relatively recent. Do you know how old that one is with him?
I don't necessarily think that the case is particularly old. I just know that there are young victims involved in it. So it's a more sensitive issue, I think.
All right,
I mean, that to me would be the only sort of thing that differentiates it from this case in my mind.
all right. Well, let me start with this, Mr. Rolla. If we treat this as a request from Mr. Truce to adjourn this trial in light of the scheduling conflict, what do you take any? Does it?
Wouldn't
do you
object,
object?
Judge. Obviously, the PAP case we were gonna have to go first, that had priority, but as to the Thompson matter, people have no objection. It's not a situation where we're worried about loss of evidence or anything of that nature, not with the nature of the charges.
All right, so we'll adjourn this trial then in light of there not being an objection from the prosecutor. So we'll reset this for a 1-day jury trial. I'm not going to set it for a final status conference since it sounds like Mr. Thompson wants to go to trial. So Mr. Thompson, that trial for next week's gonna be adjourned. We're gonna reset that. You'll be notified of the date and time of that jury trial. We will not be having any hearings between now and the date of that jury trial. And I don't care what the weather is. I don't care what's going on. If you need to be present for that jury trial date, if you're not present, or we'll issue a bench warrant for your arrest. And once you're apprehended, you'll be held in the Otsego County Jail till we can get you another trial date. Do you understand that?
Yes.
Okay. You also need to stay in touch with your lawyer. That's very important.
Yes.
All right. Mr. Trush, anything further today?
Just that I appreciate the accommodation, Your Honor. It's always a fine line when there are stacked trials between, how we think they're gonna resolve and how they actually do. And I try not to press the panic button too early.
Understood.
Clearly, I missed the mark on this one.
We need to at least be aware of the conflicts, especially when it's same circuit. So
Understood.
all right, Mr. Roll, anything further on this file?
Not this file, thank you.
Mr. Thompson, do you have any questions at all?
No, thank you.
Okay, that's all for this hearing today.
Okay.
you ready on Mr. Hooker's case?
I am, Your Honor.
Mr. Hooker, come forward, please. All People versus Kevin Hooker, file number 256908.
John, I call back.
Hey, Your Honor, Richard Trish, appearing on behalf of Mr. Hooker.
The record should reflect Mr. Hooker's present here in the courtroom today. This is the date and time set for sentencing. Mr. Hooker, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, Your Honor.
Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do you have any additions, deletions, or corrections? Any challenges by the people?
No, Your Honor.
Anything on behalf of the people for allocution?
Briefly, Judge. This is a situation where I don't have to explain to the court the circumstances of the dangers of methamphetamines. As far as jail time being held in abeyance, people do have some concern with that scenario, as this is a second felony, third controlled substance, second controlled substance delivery charge. I leave that, of course, obviously that's to the court's discretion as to how you want to proceed, but it would be a situation we think jail is appropriate in this circumstance.
Thank you, Mr. Trush.
Your Honor, did the court get, I have some information from Catholic Human Services about his counseling.
I did not.
No problem.
That may approach.
Yes. Mr. Church.
Thank you, Your Honor. This is sort of a sad situation. The history for Mr. Hooker, I think, shows that he really can be a good law-abiding citizen. He's done that for the vast majority of his life. This is a situation, and as I look at this, you ask yourself, how does somebody at 52 years of age with really very minimal criminal history, a pair of misdemeanors, how do we wind up at this place? And the story here is pretty sad. Mr. Hooker, I think, was doing all the right things and being, a normal, responsible member of society, and he experienced a loss. He experienced the loss of a significant other, and frankly, I think he kind of found himself at an older age in life and alone and kind of lonely, and he got himself involved with the wrong person. And the person that he got himself involved with was involved with drugs. And I think what we see in this is a very misguided attempt to sort of cultivate that relationship. He let himself get involved with this person. It was a new relationship for him after really a long time of not being in that situation, really not being in like a dating relationship. He was lonely, and again, he let himself get drawn into a bad situation. I think the positives here are important. I mean, they don't indicate a continuing pattern of him doing this. His last conviction was a misdemeanor, almost 20 years ago. He doesn't present to the court as a drug dealer. I don't think he presents to the court really even as a drug user. I think he presents to the court as somebody who got tangled up in a bad situation and really wasn't thinking the way that he should. Wasn't thinking that someone who is asking him to do that is not someone that he should be in a relationship with, and not someone who's looking out for him. he has accepted responsibility for what he did. He made no bones about it. He didn't run a preliminary exam, came in here, I don't remember if it was our first or our second status conference in circuit court, made admissions. He didn't draw this out into a long thing. He's got himself into counseling. He's addressing the issues, which again, frankly, I'm not convinced that the issues are substance abuse so much as they are interpersonal, dealing with the loss and setting healthy boundaries. And again, sort of entering the next stages of his life. I'm not going to ask the court here to excuse the behavior, but with a guidelines range of 0 to 18 months, I think that it is appropriate to give him an opportunity on probation to show you that this is an anomaly. This is a blip and it's not representative of who he is. And again, I think that bears out both with his history and what he's going to show you on probation. Thank you.
Thank you, Mr. Hooker. Anything that you wanted to say today?
Only that I'd like to thank you, Your Honor, and the court for the time and effort that you put into this. And I don't want to draw out with any excuses, but I accept your sentencing. Thank you.
All right. I did review the pre-sentence report, so I'm familiar with the circumstances here, at least as they're set forth in the police report as reflected in the pre-sentence report. And, I don't know what the circumstances were in this particular case. I know that, by definition, when you sell a controlled substance to someone else that you don't have legal authority to do, that's dealing drugs. So I don't know, we can use all kinds of different terms for it, but when it comes down to it, that's what you were doing. So, that's a problem for the court when you're putting under whatever circumstances that kind of substance into the community. It's something that, as a court, on behalf of the community, I have an interest in deterring and stopping. I also recognize that you do have a fairly minimal record, and there's been a lot long gaps in your criminal history, and that warrants consideration, because what that tells me is that there's a good prospect for rehabilitation here, and that there is good reason to believe that you can move forward from this and go back to where you were before. So for those reasons, I think what's appropriate here, number one, is probation. I agree with that, having some supervision, some oversight to make sure you're getting on the right path, staying on the right path. I think following this program through Catholic Human Services is an important component of that for you. So I hope you do follow through with that. I think holding some jail time in abeyance so that, number one, it gives you the opportunity to avoid jail by following through with your probation. But it also provides the court with some assurance that if you don't do that, there's going to be a penalty at the back end of that. And a fairly substantial penalty. I mean, the guidelines are 0 to 18, so the court would be justified in sending you to prison for up to 18 months. I don't think that's appropriate, but I want you to understand the seriousness of what we're talking about. And hopefully that provides an added motivation to you to stay on the right path. So for those reasons, I am going to place you on probation for a period of 18 months. I'm going to adopt as the conditions of that probation all the terms and conditions that are listed in this report. So it's important that you go through all of those with your agent so that you know what your restrictions are going to be for the next 18 months. I'm going to impose 9 months in the Otsego County Jail with credit for 2 days served. I'm going to hold that time in abeyance to be served at the discretion of the court. So what that means, Mr. Hooker, is if you violate your probation, or even if you're alleged to have violated your probation, I can impose any or all of that jail time immediately. Do not pass go, right to jail. So again, I think it's really important for you to understand that you have to abide by the conditions of your probation to avoid the jail time. If you do, then you'll never have to serve a day of that. If you don't, then we'll go the other way. The court's going to impose a crime victims assessment of $130. Court costs of $325, attorney fees of $350, $68 state cost. Restitution of $200 to be paid to the Otsego County Clerk to be dispersed to Straits Area Narcotics. And a $30 supervision fee per month while you're on probation. You do have the ability to seek an appeal of the sentence, and Mr. Truce, can you have Mr. Hooker now receive his rates? And Ms. Davis, are you just gonna meet with him right after?
I was just gonna tell him. Thank you.
Thank you.
Just for your records.
So Mr. Hooker, before you leave today, just meet with Ms. Davis and good luck to you going forward.
Thank you, Your Honor.
Oh, did you want this back? Yes. Our next hearing's at 9:45 with Mr. Love. Mr. Truce, if you can just let us know when you're ready on that one.
Just to give the court an indication, I did receive a message from Mr. Love. He indicated that he's running about 10 or so minutes behind. He got stuck by a snowplow.
Okay. All right, we'll be in recess for a few minutes. People versus Daniel Renolette, file number 236505.
Thank you, Your Honor, for Trish, on behalf of Mr. Ronelli.
All right, this is set for a probation violation hearing today. Mr. Trush, how did we want to proceed?
Your Honor, to the best of my knowledge, this is set for a contested hearing. It's our intentions to proceed forward. I would indicate Mr. Bernicell and I exchanged some emails last week. But I think we're proceeding forward.
Okay, Mr. Rowland.
My apologies to the court for being late. There's a long, cold walk.
Yeah, well, the thing not to do is to call the clerk's office and swear at the clerk.
I didn't know I swore. I apologize.
You did.
I did not know I did. I apologize. I know that.
And
it was not my intention.
And don't make up excuses like you have some kind of contagious skin disease.
I do have it all over my back. I've had it for 6 months.
Okay.
Highest records for months.
Well, then if you had it for 6 months, you knew about it way before 20 minutes ago.
It came and went. That's why.
Oh, it's one of those coming and going ones.
I'm not gonna argue.
Yeah, don't argue. You're just gonna dig yourself a hole because there's no excuse.
I'm not gonna argue with you. Sorry, I apologize.
Your Honor, and Mr. Trush, you could probably, because Bernicell said that he sent you an email stating that this case is still pending, it was adjourned. His driver license suspended.
Final conference tomorrow. That was like paperwork there. What do I say?
It was. My recollection of the last hearing from the judge was the judge indicated one way or another we were going forward today. And again, if the request is to adjourn it and let the other case resolve, I don't oppose that. I mean, that seems like a logical way to proceed. I mean, it's a misdemeanor driving on a suspended license.
And that is the basis for the probation violation, Judge. It would seem to make sense to the people that if that's being resolved tomorrow, then that would be definitive and there'd be no need for a hearing in regards to contested hearing in regards to the probation violation, because he'd have already played.
All right, well, here's what I'm gonna do, because as ridiculous as I think Mr. Renolette's position is, the fact is he made it here today from Traverse City. Today was the date for the hearing. If the people aren't ready to go forward, then I'm gonna dismiss the.
And that's fine, Judge. People have an objection to that, he made it case.
Yeah, so, Mr. Renolette, your walk wasn't wasted. The court's dismissing the probation violation, so
Thank you.
you're done.
I will provide some court, some medical records to the court. All he said. I have a stack of them.
I don't need that. I just
don't want you to think I'm making excuses up, because that's not the case.
Yeah.
I don't run from my mistakes.
Okay, all right. That's all for today.
Thank you. Have a good day.
People versus Larry Love, file number 256902 and 6903.
The record time, I call back to people.
Thank you, Your Honor. Richard Kirsch on behalf of Mr. Love.
The record should reflect Mr. Love's presence in the courtroom today. Mr. Trush, how did we want to proceed?
Your Honor, a little, I guess I'm a little perplexed by the timing of the status conference here. I think I had notices for trial out in March. And, we have a status conference here today. I think we were here last month. Not much has really changed in that time frame. I would still suggest to the court, I think a final status conference closer to the trial date would make sense to address potential evidentiary issues and those kind of things. But we're not in a position, our position isn't any different today than it was a month ago. It's still our intentions, to proceed to trial. I do think a status conference closer to a trial date would be good for evidentiary issues.
I'm just wondering if this was one of those where there was one file was already up and the other one we were waiting to make it up. So we set them both for a status conference today. Is that possible?
Judge, perhaps I can assist in that regard, that would have been the circumstances. There's another matter that was pending that, that's why we have two files, and now they're both in circuit court.
Okay.
Judge, Mr. Love explained it to me, he's absolutely right. We do have a trial set in March in Crawford County.
Okay.
These cases are up because we haven't yet set them for trial.
Okay.
So that would explain why we do have status conferences on them.
All right. Because I was looking in here and I did not see any trial notices. So that was going to be my next question.
Yep, what happened was I got the notice that said Larry Love and it's stuck in the wrong file.
Okay. So these files, how do you want to proceed?
Your Honor, we would ask that we docketed for a trial. Again, we're still working towards potential global resolutions. We're not there yet. Again, I'm cautiously optimistic that all the pieces are there to make it work, but I don't know.
Judge, of course, Commissioner, I'd like to place a plea agreement on the record if that hasn't been done yet.
We can do that, but first I just want to cover the scheduling part of it for trial. Are these going to be consolidated? Are these related offenses?
Most of the witnesses that they're saying they're not all the same, Judge, but it does relate to the same matter, so I do anticipate a motion to consolidate.
You know whether you would be opposing that yet?
I don't believe we would be opposing that.
Okay, so I'm going to schedule these together for trial purposes. If there is an objection, Mr. Drew should have plenty of time to file that and raise that issue. So we'll set them both together. Mr. Rolick and the people be ready in 90 to 120 days.
I'm just checking one thing, Judge, on the latter case. Was on the former case, that's it. I think 90 days is sufficient, but what I wanted to check is on the newest case where the controlled substance has been sent to the lab yet. And that was only my only concern.
Okay. Mr. Trush, can you be ready in that time frame, 90 to 120?
Yes.
Okay. And Mr. Rolla, how many days of trial do you think we'll need?
I'm looking at witnesses. That's almost nothing. I think it's going to be a 4-day trial, Judge. Has a total of 6 witnesses, but 2 are the same, so it doesn't really, it's not an increase, it doesn't go to 8.
I think we'll set it for 2 days just to be safe.
Very good.
I would think that's probably wise.
Okay. All right, and then as my practice is, we'll set it for a final status conference prior to the trial date. That will be the plea and motion cutoff. And Mr. Rolla, if you wanted to put that plea offer on the record.
All right, Judge, give me a moment, I have to get back to it.
I think I could probably do that. I believe that the offer was a single count of possession in each file. That's the offer that I show.
It would have been added count 2 of possession and dismissal of count 1 in one file, dismissal of each of 4, and of course, possession with and then plea to count 1 in the file, correct?
Okay. So, Mr. Love, there'll be one more status conference in this case prior to your trial date. And that would be the last day to enter into a plea agreement. So between now and then, it's important that you talk to Mr. Trush and that you're ready with a final decision at that.
That's really good. You gotta keep in touch.
Okay. Anything further on these files, Mr. Trush?
Not at this time. Thank you.
Mr. Rolla?
Not for the people, thank you, Judge.
Mr. Love, do you have any questions about how we're going to proceed? Okay, thank you. All right, sir, is your name James Terbruggen?
Yeah.
Okay, Mr. Dick, were you ready on Mr. Terbruggen's case?
Yes, Your Honor.
We'll go on the record in People versus James Terbruggen. This is file number 256915. The record should reflect Mr. Terbruggen's present by video from Otsego County Jail. If I could have counsel put your appearances on.
James Dick on behalf of Mr. Terbruggen.
Thank you. Mr. Dick, can you tell me the status of this file from the defense position?
Yes, Your Honor, we do have a case resolution where Mr. Terbruggen will be pleading guilty to counts 1 and 2 as a habitual second in exchange for dismissal of counts 3 and 4 and the habitual fourth notice. And there's also a restitution amount of
$784.
$784.
Okay. Mr. Terbruggen, were you able to hear that?
Yeah.
And is that the plea, that agreement that you've discussed with your attorney?
Yes, sir.
Did you want to go forward with that plea today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Terbruggen, are you on any kind of probation or parole?
Parole out of Antrim County.
Okay. So that's parole from the Department of Corrections, is that right?
Yeah.
Okay, so do you understand that any sentence in this case would have to be consecutive to any parole violation penalty you might face?
Yeah, I understand that.
And you understand that you also would not be entitled to any jail credit because of your parole status?
Yeah, I understand that.
Okay. And then you're pleading guilty to 2 counts of use of is this a use or a theft of a control?
It was use of without permission of a financial transaction device. Your Honor.
Okay, use without permission of a financial transaction device or credit card or debit card. 2 counts of that, they each carry a maximum possible penalty as a habitual second offender of up to 6 years. Do you understand that?
Yes, sir.
With all of those things in mind, what is your plea to those 2 charges today?
I'll plead guilty, sir.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yeah, I understand that.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've stated here in court today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are actually guilty of these charges?
Yes, sir.
The time frame I have is in April of 2025, on or about April 21st or 22nd of 2025. Is that the correct date?
April 21st, sir.
Okay. On that date, did you use a some type of financial device, whether that was a credit card, debit card, or something like that?
Yes, sir.
Did that card belong to another person?
Yes, sir.
And did you have permission to use that to purchase goods or get cash or do something on your own behalf?
No, sir.
And did you do that twice?
Yeah.
Okay. Counsel, are you both satisfied with the factual basis?
Yes, Judge.
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people, thank you.
None, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Yes, Your Honor.
Thank you. Mr. Turbergen, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from the probation department will be in touch with you to do a pre-sentence investigation. And then you'll have an opportunity to go through that report with your attorney prior to the sentencing hearing.
Excuse me, Judge. The court's going to confirm his prior conviction, the one he's on parole for, that's ahead. I know he already indicated he was on parole for it, but I think the court needs to do that, though, for the record.
Yeah. Mr. Turbergen, were you convicted of forgery in the 13th Circuit Court in Antrim County back in 2021?
Yes, sir.
Okay.
Thank you, Your Honor.
All right, Mr. Turbergen, that's all that we have for today. Do you have any questions?
No, sir.
Thank you. The court's going to disconnect at this time. Are you Mr. Whitmer? No.
He's in custody, Your Honor.
Oh, yes.
Yes.
Okay. So,
Two in custody.
and Lancaster.
Yes, sir.
All right, let's take a short recess. If we can have Okay, we're on the record in People versus Christopher Whitmer. This is file number 256904. The record should reflect that Mr. Whitmer is present here in the courtroom today. This is the date and time set for sentencing. If I can have counsel put your appearances on.
Thank you. For the record, I call the people.
James Dick on behalf of Mr. Whitmer, Your Honor.
Mr. Whitmer, did you have an adequate opportunity to go through the pre-sentence report with your attorney?
Yes, Your Honor.
Okay. Mr. Dick, are there any additions, deletions, or corrections to that report?
Your Honor, yes, there are a couple corrections that it should be noted. CFJ 284, Your Honor, page 6, under family. Mr. Whitmer's sister, Jennifer LaBeouf, she resides in Philadelphia, not Michigan.
Okay. Any objection to that change, Mr. Rowland?
No, thank you.
And under marriage, Jessica Sinandi, she lives in Tennessee, not Michigan.
Any objection to that change?
Not at all. Thank you.
The last. Oh, sorry. There's a couple more. My apologies. The employment narrative, the third sentence, he receives Social Security. He does not currently receive any Social Security. That's been terminated.
Any objection to that change?
No, Judge.
Okay.
The next page, Your Honor, CFJ 284, page 7, substance use and treatment. The methamphetamine, it was listed as unknown, the start date. It should reflect 2008 as the start date to present.
Any objection to that, Mr. Rowland?
Judge, I have no information to counter that information.
Okay.
And then lastly, the substance abuse treatment. The inpatient at Gaudenzia, the end date was 36 days after the January 1st entry date.
Okay, so February 5th? That sound right?
Yes, sir.
Right, yes.
All right, we'll indicate an end date of February 5th. Okay.
No other additions, deletions, or corrections, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor, find them acceptable and accurate.
Thank you. Mr. Rowland, do the people have any additions, deletions, or corrections?
I do not, but I thought the defense also had an additional document from Mr. Whitner. I
Yes.
lodged to court.
Not yet.
Okay.
But no objection to court proceeding.
Mr. Dick, when you go back, can you move that podium that way?
Yes,
I can't see Mr. Rowland. Thank you. There we go. Perfect.
But other than that, just no additional additions or deletions.
All right, Mr. Rolla, do you have any challenges to the scoring of the guidelines?
No, Judge.
Anything on behalf of the people for allocution today?
Yes, please. Thank you. This is the defendant's first felony. However, as is made very clear from the PSI, the defendant traveled all the way from Pennsylvania to Michigan to commit this offense. And unfortunately, the reality of the circumstances, as I understand it, and as indicated in both the police report and the PSI, the defendant is one of many individuals, many of them homeless, that an organization was using multi-state to commit these same type of offenses, not just in Michigan, in many counties, but in other states as well. There's a guideline, a guideline of 0 to 6 up to 5 years with a recommendation of 6 months with 93 days credit. The situation that we were advised of this morning is that the defense is asking for placement in a Lions Den facility. And again, that may be fine. However, the problem that people have with that is it's not a lockdown facility. The people's concern is that the same type of situation that arose to have Mr. Whitmer come all the way from Pennsylvania would still exist, and effectively, because the individuals that are using these people, like Mr. Whitmer, as pawns to do their effectively illegal other crimes, just pick them up all over the place and then take them and commit crimes elsewhere. I don't think that that's an appropriate circumstance. I think at a minimum, even though it's a first felony, there should be some verification that we know where Mr. Whitmer is, because even his own family didn't know where he was because he was a homeless individual. So that's a concern of the people. Thank you.
Mr. Dick?
Yes, Your Honor. So as Mr. Ellis stated, Mr. Whitmer was used as a pawn in this matter. However, he takes responsibility for his actions of walking in and actually doing what he admitted to do. The history that he has, most of it is all substance abuse related, and that played a factor in him doing what was done during this particular incident. Mr. Whitmer, he, as it reflects in the PSI, he's not had contact with his children or his wife, who he's separated from for approximately 9 years, because he finds some sort of shame in his substance abuse. And he noted when discussing this with the probation officer that he intended to contact them once he was clean. Now, when this PSI was written, the original tentative date of sentencing would have given him 93 days of credit. I believe that is now roughly under 20. So if he were to serve the additional time, even for the 6 months, I believe he would have around a month left of his time in custody. Mr. Whitmer has made affirmative efforts to reach out and be accepted to the Lions Den because he wants to change his life. He knows that he could just sit in jail and do these additional 30 days or whatever it might be, and then perhaps walk away if the court was to adopt the recommendation. But that's not what he wants. He would like to commit to the 8 to 10 month program at the Lions Den to take advantage of the support that they offer, the guidance that they offer, and to help him establish a new life. He's looking for a clean start after this incident is, a clean start in general once he is completed at the Lions Den. If the court would be willing, I think it would be reasonable to allow him to attend the Lions Den as a rehab facility, although he is dried out from his substance abuse after being in custody at the jail for the period he has been. It will help with his reprogramming. It will give him guidance, and he does find hope in God. So with that being said, Your Honor, the Lions Den does report right away if somebody were to leave their facility. Mr. Whitmer, he admittedly has nowhere to go. He's lived in homeless shelters and whatnot for many years, and he hopes to establish some sort of a life and home for himself. And he has expressed to me that he likes Michigan. It gets him away from what he was dealing with back in Pennsylvania. With that being said, Your Honor, we would ask that the court permits or extends him perhaps probationary period to allow him to show that he is actually trying to change his life. And court would have the reporting from the Lions Den should any of his circumstances change. That being said, I don't have anything further.
Thank you. Mr. Whitmer, did you have anything you wanted to say today?
I just want to say, I just want to apologize to the court. Sorry, I was in church at the time. I'm working on my substance abuse, and I've been clean for about 4 months, and I'm feeling great. You know, getting in contact with God. I never like government church services. You know. I feel very, I'm very, very good about myself. So I want to share.
All right, Mr. Whitmer, I did review the report, so I'm familiar with your background, your circumstances generally, as well as what happened in this particular case. This crime is concerning from our community standpoint, and we have folks coming in from other areas of Michigan or different states specifically to victimize our community. As a court, I have an interest in punishing and deterring that kind of conduct.
Yes.
And so I think a jail sentence is appropriate. You know, based on your record, what happened, I don't think probation is necessarily an unreasonable option, but given your lack of any ties to this community, any individuals that are local that could vouch for you and say, hey, we're going to keep an eye on him and make sure he's doing what he's supposed to do, then I think maybe it would be more appropriate. But in your case, I don't think probation is something that's going to be helpful to the community or to you, frankly. I do think the Lions Den is a great program. A lot of people from my court here, and particularly in Crawford County, participate in that program. They do an excellent job. But Mr. Roll is exactly right, and that's the first thing I thought of when I saw this, which is they don't force you to stay there. So I could let you out, you could go there tomorrow, and Friday you could decide you want to go back to Pennsylvania. And yeah, they'll let me know that you left, but that doesn't do us any good because you're gone. And based on your lack of any ties to the community, based on anybody here local being able to say, yeah, we're going to keep an eye on him, we're going to make sure he stays there and completes this program. I don't have any, and based on what happened in this case, I don't have any confidence that if I were to release you early or have you go there, that you would actually complete that program. And the fact of the matter is, once you've served your jail term, if you really want to do that, you can go right there if you want to.
Yeah, sure.
So I think the recommendation is appropriate. I think it's fair. I think it provides for a degree of punishment and deterrence so that other folks know if they're going to come here to try and commit these kind of crimes, that there's going to be a penalty to pay for that. The court is going to sentence you to 6 months in the Otsego County Jail. I did calculate that credit because this was set for sentencing on November 5th. So I come up with 120 days. Did you?
121 actually, Judge.
121, okay, 121 days. So 6 months of credit for 121 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, the DNA testing fee of $60 and a $68 state cost. You do have the ability to seek an appeal of the sentence, and Mr. Dick, have you provided the appellate rights to Mr.
Yes, Your Honor.
You can have him. Mr. Whitman, you're amended to custody of the county. So we're gonna take just a short break while Lancaster's brought from the jail. You need any time to speak with him, Mr. Dick, or are you ready to? Mr. Roll, I'll just have you make an oral argument, and if I need to stop to review your brief, we may have to take a break. Sorry about that.
No, that's fine.
She had the lawyer.
You did.
Lisa Gray.
And Judge,
I'm sure.
confusion might be the fact that she had them in two different courts. One was the district court, one was the circuit. Which is why I know I did briefs because I had to do two of them.
Yeah, I do have a Gray on here, an
Gray.
attorney Gray.
Okay.
Sorry about that.
Ms. Paget, are you able to hear me okay?
Yes, I can.
All right, and Ms. Gray, I can't see you.
Yeah, Your Honor, I apologize. I don't know what's going on with my video.
Are you appearing on behalf of Ms. Paget?
I am.
Okay. Let me, just 1 second here. Okay, we'll go on the record. This is People versus Suzanne Paget. File number 82-848-FY. And for the record, Ms. Paget is present by Zoom along with her counsel, Ms. Gray. Mr. Rolla is present here on behalf of the people. So Ms. Gray, just to let you know, I didn't have this on my docket, so I'm kind of addressing this on the fly here today.
Okay. Thank you, Your Honor.
I think we can go forward.
Okay, yeah, just for the record, I know we did send in, I confirmed we did send a notice of hearing, but I did speak with your clerk earlier this week, and we don't know what happened to it. It apparently was not received, or perhaps it's lost in the mail, but I did verify that we sent it and we worked with the court to get the date. But the application that is currently before the court is based on a conviction that is 42 years old. The last conviction on Ms. Paget's record occurred over 25 years ago, and Ms. Paget's circumstances and behavior have changed drastically since the conviction was entered. She's a 76-year-old longtime resident of Gaylord, Michigan. She is a mother of 4, a grandmother to 14 children, and a great-grandmother to 14 great-grandchildren. She is a valued member of her family and community. She was a caregiver for her terminally ill family members and has held a number of jobs in the community throughout the years. She attends church on a regular basis and donates to charities. And over the last 20 years, she has exemplified her commitment to better herself, change, and make positive contributions to her community. She applied to have her conviction set aside so she could potentially advance her job opportunities in order to improve her employment opportunities to supplement her Social Security income. There are jobs that she'd like to apply for, but she would be prohibited with a certain criminal history. One of the main things she has as a goal is to work as a caregiver for elderly people. Even though Ms. Paget herself is an elder, she is in very capable condition and has the experience necessary to do this. She said even if it's on a volunteer basis, she'd like to do it. But as far as she knows, her criminal record would prohibit her or hinder her from doing those positions. So I believe that setting aside the conviction would be consistent with the public welfare and the purpose of the Michigan Clean Slate Law. She'd have better opportunities for employment and would work to better the community. And I don't know if the court received the prosecutor's brief objecting to setting aside this conviction. I believe the prosecutor filed a brief and we filed a reply.
Yeah, so I didn't get a chance to review those. So I don't know, and I'm gonna ask you this, Ms. Gray, first, without my having had an opportunity to review either the the objection or the written response. I mean, do you want to reset this until I've had a chance to do that? Or do you want to just go forward today?
I would prefer to go forward today, and I suppose I could explain why, for a number of reasons. So the district court, Ms. Paget had a 1981 conviction for a misdemeanor of fleeing and eluding. The district court and Judge Hesselink denied her petition because they believed that the interpretation of MCL 780.621 D4C would prohibit that, as it was a conviction that occurred. So the statute read with the calculation of the time period that would determine her eligibility to file a petition. That portion of the statute reads that the applicant has not been convicted of any criminal offense during the applicable time period required under subsections 1, 2, or 3. So Judge Hesselink believed that because there was this 1983 conviction, that would prohibit her from being able to set aside the 1981 conviction. We have filed a motion for reconsideration on that issue based in part on the possible outcome of this case. And in it, we discussed that the language of the opinion of court, K-O-E-R-T, and I apologize, I did send a copy of that along with my reply brief. But the court opinion and the language of 780.6221 state that upon the entry of an order under section 1 or 1E, or upon the automatic setting aside of a conviction under section 1G, the applicant for purposes of the law is considered not to have been previously convicted. And so I believe the prosecutor is also taking issue with, I think, a 1989 conviction that had already been set aside. But we're saying it would be consistent with this language to interpret that later conviction as though there was no conviction. And therefore, regardless of how the court believes that provision of 780.621 D4C should be interpreted, there would be no conviction following today's conviction. So there would be no 1989 conviction.
Okay, so just to kind of summarize your position, you're kind of arguing that it's like a domino theory where if you take out the later conviction, then it eliminates a conviction within the applicable time period. So if you keep working your way backwards, as long as they're continually set aside, you can continue to go backwards. Is that kind of where you're at with that?
Yes. So under the circumstances with that interpretation, whether or not Your Honor decides to set this one aside could have an effect on her petition to set aside the 1981 conviction.
Right, understood. And you're saying that because apparently there was an 89 conviction, because that one was set aside, that one is not a bar to setting this one aside.
Correct. And that would be me in response to the prosecutor's position.
Right, okay. So Mr. Rowlett, I'm guessing your position is that this 89 conviction was within the applicable time frame. So
it was, Judge, and the problem with the argument the defense is trying to make is, quite frankly, well, we can just keep having things set aside, then we can go on, then we can set more aside, we can set more aside, and we can have 100 convictions set aside because those don't count.
Right.
That's just wrong as a matter of law. That's wrong as a matter of fact. And as I indicated in my response brief, and I agree, quite frankly, with the district court's findings that that Judge Hesselink made, it's clear that the statute under which the petition in this case is asking to be set aside, MCL 78621D, and for the record, this is case number 82848 FY3, indicates the particular time period. If it's a misdemeanor, a high misdemeanor, or a low felony, it's a 5-year period. If it's a higher offense or it's an offense of an assaultive offense, it's a 7-year period, going from the date of the offense. The other problem you have, of course, is when the application is made. I'm sure this court's seen numerous of those before. The person filing it says, I have had no convictions within this time period. But they know that those are out there. So they are either filing a false application or they're just asking the court to look the other way. Never mind, we think this might get set aside at a later time, so you can't count it. That's quite frankly contrary to law. As I indicated in my response brief, in objection to the defendant's motion, the defendant, Ms. Pageant, she's filing to have her 10/24/1983 conviction for a police officer resisting, obstructing, attempted set aside. That was the 87A district court case that was being referred to. The court originally, if you recall, had this matter scheduled for a hearing on Wednesday, October 8th, 2025. But that hearing was subsequently adjourned at the request of defense counsel. We then have the situation, we're looking at the defendant's record. The defendant on June 10th, 2025, then filed an application to have her September 15th, 1981 conviction for a police officer fleeing set aside in the 87A district court case 81 FY3. That was one before Judge Heslin. As the court's well aware, even if the court were to have granted that, that doesn't remove it. That removes it from her public record. But because it's a traffic violation, it can't be removed anyway. It stays on her driving record. So that one doesn't go away. In addition, as indicated in the copy of the defendant's criminal record attached as Exhibit A to my response, it disclosed the following criminal convictions: retail fraud, first degree, contrary to MCL 750-356C, that's a felony in the 13th Circuit Court, Grand Traverse County, which was one of those that was automatically dismissed by statute as referenced by counsel. We then had a October 13th, 2000 conviction, animal cruelties, abandoning, and that was in the 87th District Court here, case number 0010456SM3. Those convictions are still on the defendant's record. And again, the express provisions of MCL 780-621-D4C show that the defendant had these convictions within the applicable statutory time period. So because of those convictions, this court respectfully is precluded from granting the request the defendant is asking. They were done within the time period. The fact that one or more might be set aside by another court at another time, or in this particular case, it's already been denied, so you still have the conviction in the 87A District Court standing. Forget setting aside the fact that they've filed a motion for reconsideration. That doesn't change the fact that at this point in time, before this court, that conviction still stands and also precludes this court from setting aside this conviction because the defendant has and still remains to have a conviction within the statutory time period. This petition should be denied.
Okay, Ms. Gray, anything you wanted to say in response to the prosecutor's argument?
Yes, we've been in touch with the AG's office, and we do anticipate that they will be filing a concurrence with our position of the interpretation of the language of the statute in our motion for reconsideration. They have indicated that that is not how they would interpret the time calculation in 780.621 D4C. Additionally, I believe that the prosecutor's math is speculative. We were unable to get a copy of the file, which would have indicated an order of discharge from probation because Ms. Paget's case is so old. So we tried to get that in support of filing with her original petition, and the court indicated it could not be produced. But Ms. Paget does recollect getting off probation early. So I don't even know if that 2 years of probation was completely applicable. But the other thing, I think the most important thing to note is that in People v. Court, which was number 363169, 2024, Mishap Lexus 1214. So that is an unpublished opinion, but they did cite and interpret the language of 780.6221, which states that upon the entry of an order under Section 1 or 1E, or upon the automatic setting aside of a conviction under Section 1G, the applicant for the purposes of law is considered not to have been previously convicted. So there's a number of So when the prosecutor says this is an issue of the matter of law, his interpretation is not actually supported by the law. The 1989 conviction does not exist as a matter of law under the plain language of the statute and the court opinion.
Okay. All right. So what I'm going to do, I think this is a circumstance where I really need to read the case and take a closer look at the statute, because this is going to call for some interpretation by the court. So what I'm going to do for today's purposes, number one, the court is going to find that based on Ms. Padgett's behavior and circumstances, since this conviction was entered, that it should be set aside. The amount of time that's passed since her last conviction, which is 25 years, 42 years since the incident in this case took place, for the reasons cited by Ms. Gray, I think Ms. Padgett's clearly moved on, clearly has gotten past the point of engaging in criminal behavior and has conformed herself to what we all expect of citizens within our community. I also find that it would be in the public interest to have it set aside. I think it's always in the interest of the community for someone to pursue a better career so that they can provide better for themselves and their families. Certainly, it's in the public interest to pursue a career like helping elderly. We don't have enough people that are willing to do that anyway. And so for someone to be prevented from doing that because of a conviction from 1983, I think would be unfortunate. So I find that those statutory requirements have been met. I think the real question is whether there's this technical issue that would prevent the court from setting the conviction aside. So I'm going to take a closer look at that. The court will issue a written ruling. Ms. Gray and Ms. Padgett, I'm going to do that as quickly as I can. I don't know, I can't give you a time frame, but I'm going to try and do it in a timely manner so that whatever the court's ruling is, that can guide you with whatever else you have going on. But I don't think I'm in a position to do that here on the record today without having had an opportunity to review those cases. So if the court finds that there's no technical bar or statutory bar, I find that the other requirements have been met and my order will indicate that the conviction should be set aside. If I find that Mr. Rolla, his position is correct and that there's a technical bar to the court setting it aside, then obviously I won't be able to do that. So that's how we'll proceed. Ms. Gray, any questions about that?
No, Your Honor. Thank you for listening to our argument today.
Okay, Mr. Rolla, anything further for the record?
No, Your Honor, thank you.
Okay, thank you. That's all for today. And Ms. Padgett, Ms. Gray, you're free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Now that concludes our morning docket. Yes.
Yes.
And Wiley was adjourned for stiff and order.
Yes. Okay, and for the record, since this wasn't on the schedule, viewer, the record should reflect that anybody looking for the transcript of this hearing, it's going to be under case number 256881 versus Lancaster. You can note that for the ROA.
Yes, I will do that.
Okay, we'll be in recess until 1:45. Mr. Rolla, I did sign a adjournment.